This is the Supreme Court case between Gerald R. Caron and the United States. Caron had been convicted 3 times for breaking and entering, as well as 1 count of assault with attempt to commit murder. In September of 1993, federal agents raided Caron's home and discovered he was in possession of 6 long-barreled rifles and shotguns, and 6,820 rounds of ammunition.
Caron was arrested on 4 counts of possessing a firearm after being convicted of a serious offense. His sentence was also to be enhanced since he was a 3-time violent felon.
Mr. Walker.
Mr. Chief Justice, may it please the Court. If a person is pardoned or has civil rights restored, the statute at issue says his conviction is considered a predicate conviction under federal firearms law only if the pardon or restoration of rights expressly provides that he may not ship, transport, possess, or receive firearms. When my client's rights were restored, Massachusetts law told him that he could possess rifles and shotguns and indeed possess a handgun in his home. He's now serving an additional 12 years on a sentence for possessing the very firearms that Massachusetts law told him that he could possess. We say it's self-evident that the statute, that it cannot be said that Massachusetts expressly provides that he could not ship, transport, possess, or receive firearms.
Caron's defense was that in Massachusetts, people's civil rights are restored after 5 years, meaning they can own long-barreled guns, but not handguns.
A federal jury determined he was guilty on all 4 counts after ruling that the restoration of civil rights could only apply after an offender-specific action, meaning only after the offender took some action to regain his civil rights, rather than by operation of law.
I think it has to be read that way. I mean, even if you're taking a literal meaning, suppose it just prohibits his not possessing handguns. Aren't handguns firearms?
Well, that's
so. In prohibiting handguns, it's prohibiting his possession of firearms.
That there is a false syllogism in the circuit court's reading of the statute, and it goes like this. Let's say you like lawyers. You like almost all lawyers, but A, B, and C are particular lawyers that you don't like. So the syllogism that is false goes like this. I do not like A, B, and C. A, B, and C are lawyers. Therefore, I do not like lawyers. It comes out completely the opposite of the truth, almost completely the opposite. The fact is you like lawyers, but if you follow that logic, you end up with almost a contrary meaning. The statute says no firearms.
After Caron was convicted by the district court, the Court of Appeals for the First Circuit determined that the court's decision was actually wrong and that Caron was entirely within the bounds of the law. They determined that this Massachusetts law in no way required any action from the offender, and Caron was legally allowed to own rifles and shotguns. Only after this conflicting decision did the Supreme Court have to get its ass involved.
Or restoration expressly provides that the person may not ship, possess, or receive firearms. It doesn't say any firearms. It says firearms.
That's correct, Your Honor. For example,
so you have to be very, very careful. So you misstated the statute.
I beg to differ, Your Honor. If the governor told her staffer, draw up the pardon for Smith, and I wanted to expressly provide that Smith cannot ship, transport, possess, or receive firearms, the staffer goes and writes those words and also adds, staffer, let's say, likes hunting, and says, but the person can have rifles and shotguns to go hunting. So the governor is looking the next day through her papers, is about to sign the part, and she looks down and says, what's this about rifles and shotguns? I told you to draw up a pardon that expressly provided that Smith couldn't ship, transport, possess, or receive firearms.
After reviewing the case, the Supreme Court decided that Caron was guilty, even though under Massachusetts law, felons are restored the right to own rifles and shotguns after 5 years. The court used the precedent of Dickerson v. New Banner Institute. This stated that jurisdiction falls to the state and civil liberties are restored unless the clause prohibits the possession of any firearms, in this case, handguns.
The justification for this ruling was that since the state of Massachusetts deemed Caron too dangerous to possess a handgun, he is too dangerous to own any gun, therefore overruling the Massachusetts state law which allowed him to own a long-barreled rifle or shotgun.
The decision to convict Caron was 6-3 in favor of the conviction. The majority opinion was written by Supreme Court Justice Anthony M. Kennedy. It stated that since Massachusetts treats Caron as too dangerous to trust with handguns, federal law uses this state finding of dangerousness in forbidding Caron to have any guns.
The dissent opinion, given by Justice Clarence Thomas, stated that the Massachusetts law should have restored Caron rights to own rifles and shotguns. He stated the generalization of Caron's being too dangerous to own a handgun, and therefore him being too dangerous to own any gun, was too broad.
This case has relevance to society because it set a precedent of dangerousness for convicted felons who are in possession of any sort of firearms, completely regardless of the state law, so long as the law prohibits the possession of a firearm, whether it be a handgun, shotgun, or machine gun.